Hi, very good morning. It's a very interesting judgment of Delhi High Court. Citation is Tata Steel Limited versus Ministry of Corporate Affairs. Issue before the Delhi High Court was whether after the resolution plan is approved by adjudicating authority, that is NCLT, what happens to the pending contingent liabilities of a corporate debtor, whether they are extinguished or not. That is the issue. Facts: Bhushan Energy Limited, hereafter BEL, entered into a contract with ISGEC, Heavy Engineering Limited, hereafter ISGEC. So naturally, if you enter into contract like marriage, dispute will arise. So disputes arose. ISGEC initiated arbitration proceedings. During the pendency of arbitration proceedings, Corporate Insolvency Resolution Process (CIRP) was initiated against BEL by State Bank of India. NCLT admitted the petition. Moratorium was imposed. Then interim resolution professional IRP was appointed. Then IRP made public advertisement and invited the claims of the creditors. ISGC also submitted its claim as operational creditor. IRP treated the same as contingent liability. In the opinion of IRP, since dispute was pending before arbitration, the claim of ISGEC was treated as a contingent liability. ISGEC, ISGEC did not accept this treatment as contingent liability, but the RP refused to accept the contention. Finally, a resolution plan was submitted by Tata Steel Limited. The Committee of Creditors approved the resolution plan submitted by TSL, Tata Steel Limited. This was approved by NCLT, the adjudicating authority. Then new management took over charge of BEL. Now, ISGEC sent a communication to the arbitrary tribunal to resume the proceedings because it was pending, initiated by ISGEC. Arbitrary tribunal found that the term has expired. So it requested the parties to seek extension of time from the High Court since the mandate got expired. At this stage, BEL preferred an application before the arbitrary tribunal under section 32(2)(c) of Arbitration Act. That is for termination of proceedings, as continuation of the proceedings are unnecessary in view of the resolution plan, because already plan has been approved by the adjudicating authority. Again, you don't initiate fresh proceedings against the BEL. Arbitrary tribunal refused to terminate the proceedings. The tribunal held that since the claim was kept as contingent by the RP, it was not a crystallized debt, and hence the proceedings will continue. The disputes are there, we will decide the issue. That is what arbitral tribunal held. Then a writ petition was filed by TSL, Tata Steel Limited, before the Delhi High Court against the order of the arbitration tribunal refusing to terminate the proceedings. Delhi High Court relied on the judgment of the Supreme Court in the case of Electro Steel case. In that case, Supreme Court held as follows. Court begins till unquote. Whatever Supreme Court said in that case is said. Only a few lines, maybe 10 lines. So, quote, it is, Supreme Court said in that case, it is by now well settled that once a resolution plan is duly approved by the adjudicating authority, all claims which are not part of the resolution plan shall stand extinguished, and no person will be entitled to initiate or continue any proceeding in respect to a claim which is not part of the resolution plan. In fact, in SR Steel case, Supreme Court had categorically declared A successful resolution applicant cannot be faced with undecided claims after the resolution plan is accepted. Otherwise, this would amount to a Hydra head popping up, which would throw into uncertainty the amount payable by the resolution applicant. That is like heads like Ravana. Again and again something comes up. So that should not be there. Lifting of the moratorium does not mean that the claim of the respondent, in that case, would stand revived, notwithstanding approval of the resolution plan by the adjudicating authority. Moratorium is intended to ensure that no further demands are raised or adjudicated upon during the CIRP process so that the process can be proceeded with and concluded without further complications. Since the resolution plan was approved, the claim of the respondent stood extinguished. Therefore, the Facilitation Council in Electrosteel case did not have the jurisdiction to arbitrate on the said claim. Since the award was passed without jurisdiction, the same could be assailed in a proceeding under Section 47 of CPC, that is, even in the execution proceedings. The view taken by the High Court that because the appellant did not challenge the award under Section 34 of the 1996 Act, that is Arbitration Act, it was precluded from objecting to execution of the award at the stage of Section 47 of CPC is wholly unsustainable. Supreme Court held that the view taken by the High Court that notwithstanding approval of the resolution plan by the NCLT, Facilitation Council did not lose jurisdiction to proceed and pronounce the arbitral award is erroneous and contrary to the law laid down by Supreme Court. Supreme Court finally held that upon approval of the resolution plan by the NCLT, the claim of the respondent being outside the purview of the resolution plan, it stood extinguished. Now unquote. So that is what this everything has been said in that Electrosteel case. Now Delhi High Court dealing with the present case, that is TSL case, BEL case. Delhi High Court noted that in the present case, contingent liabilities were dealt with in the resolution plan. So it looked into the resolution plan and how the contingent liability was dealt with in that resolution plan. Delhi High Court. The resolution plan said each such contingent liability is a claim and debt as defined under the IBC and would consequently qualify as operational debt. The full amount of such contingent liability shall be deemed to be owed and due as of the insolvency commencement date, the liquidation value of which is assumed to be nil. Therefore, no amount is payable in relation thereto. This is what the clause said. The resolution plan clause said it dealt with the contingent liability and said the value will be assumed to be nil and no amount is payable in respect thereof. That is what it said. Delhi High Court also noted another clause which dealt with matters which were sub judice. The same treatment was given. That is, the amount will be deemed to be nil and there no amount is payable even in respect of matters which are sub judice. That is what the clause said. Delhi High Court said, even if the claim was considered to be contingent, it was considered and rejected in the resolution plan. This was approved by the adjudicating authority. ISGC raised a contention. It said, a contingent creditor is no creditor in the eye of law. And on such a classification, that is as contingent, ISGC was removed from the CIRP. And therefore, the resolution plan which was approved by the adjudicating authority will not bind or would not bind the ISGC. But this contention was rejected by the Delhi High Court. Delhi High Court held the arbitration tribunal has no jurisdiction to proceed in this case. And allowed the writ petition filed by the Tata Steel Limited. So, interesting case. Thank you very much. Have a great and wonderful day. Bye.